topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good morning, Philadelphia. Welcome to the Ask the Expert show. And as always, our shows are sponsored by the Michael Cardamone Law Firm. He's a certified specialist in workers' comp law. His phone number is 215-206-9068. We have got a great show for you today. We are talking workers' comp law. And folks, let me tell you, I've been doing this for 12 years now. And when you have an attorney that devotes his entire practice to one area of law, I'm telling you, that is the way I would always go. And so let me introduce you now, our expert in workers' comp law, certified specialist, Michael Cardamone.
Good morning, Steve. How are you?
I'm good. I have to get used to saying certified specialist because in other markets, it's board certified.
Yeah, and there's also board certification for doctors, so it can be confusing. But for workers' comp in Pennsylvania, if you pass the exam and meet all the other criteria, then you're a certified specialist in workers' comp. So the phrase is actually longer than that. We're supposed to use it's a certified specialist through the Pennsylvania Bar Association as approved by the Pennsylvania Supreme Court, but we kind of abbreviate it because that's a mouthful. So,
well, Michael, you know what? We get new people every week joining our show. And tell people, first of all, about your firm.
Sure. So as Steve said, we are 100% focused on workers' comp for injured workers, making us pretty rare in the state of Pennsylvania. There's a few other firms that focus 100% on comp, but not too many. And so we're a small boutique firm. We have 2 attorneys and a great staff. We're bilingual with Spanish. We have offices in Lansdale and Philadelphia primarily, but also some space in the Lehigh Valley and Lancaster as well. So we're always happy to meet with our clients where they reside, or they can come to us, or we can do a Zoom call. We're really flexible with that, whatever makes our clients comfortable. And so we've been around since 2014, and our recipe works. People come to us when they have serious injuries. They know that we're no nonsense and we don't handle lots of different areas of law. It's just workers' comp only with us.
Michael, where do you see most of your clients coming from? Is it in the construction area?
It's really diversified, but that is definitely one really ripe area of the economy where we get clients: construction cases, truck drivers, still some assembly line workers, Amazon workers, for example, a lot of healthcare workers, nurses, CNAs, people like that. But it could be, I've represented a pharmacist before, tripped on a computer wire, then had a bad concussion and had a really serious brain injury. So it really can really run the whole gamut. But yeah, 80-90% of the time it's in a field where it's really hands-on, warehouse workers, the construction workers, etc.
I started off today's show with Good Morning Philadelphia because we've done that for the last 12 years, but it's no longer Good Morning Philadelphia. It's Good Morning Pennsylvania. We now cover all of Pennsylvania, not just Philadelphia. So we didn't mean to leave anybody out. It's just after 12 years of doing this, I am so used to saying good morning, Philadelphia. So, hey, let's just jump right in. And I've got so many questions for you, Michael. But I'm going to start off first because one of the biggest questions is people who are injured don't understand how you get paid.
Yeah, it's a contingent fee system. And what that means is you don't pay us anything out of your pocket. No check, no cash, no Venmo, nothing. And if we win and there's a court order approving our victory or settlement, then there'll be a 20% award. My firm only takes an award on the indemnity or wage loss benefits. There are some firms now that are taking a fee on medical. I'm not comfortable with that, so we don't do that. But so yeah, you don't need any cash. It levels the playing field and allows you to get representation without having to send us any checks. And people who do that tend to double or triple their money. And so sometimes they fear this 20%. Well, I can't live on my check as is, and I'm going check to check, and it's really hurting us. But when the insurance company challenges your benefits and they say you're recovered, for example, and you lose, you get nothing. So I have to explain to our clients that you can get a 20% reduction if you fight back and win, or you can get zero. And so it's an obvious choice. And with settlement, people do much better too with an attorney on their side. So it is the number one question. It's how do I pay you? I can't afford it. And we say, well, you're in good luck. You don't have to pay us anything. It's a contingent. And that's across the board. That's across the state. So it's a really nice way for people to level the playing field, because the insurance companies, they know what they're doing. They have a team of attorneys, and you want to have the same thing on your side.
Exactly. And these attorneys on the other side, these aren't slouches. These are big hitters, and they gobble up people who don't have an attorney. Now here you've got, just like Michael said, you can make the playing field level. The other question, Michael, people worry about, can I get fired for filing a claim?
You can, but it's going to be unlawful, and they're going to have probably a secondary case for what's called employment discrimination. So you're not allowed to be fired because of your race, your religion, your ethnicity, your sexual orientation, your age. If you're pregnant and you need accommodation, these kind of things. And you're not allowed to be fired for retaliation for filing a workers' comp case or getting an attorney. And that's really puts a chilling effect on people, that false belief that they're going to get hammered by their employer because they got legal advice. And it prevents them from calling us or other law firms. And in the end, they end up losing lots of money, sometimes six figures, because they were stubborn and they didn't really get that notion explained and debunked. They sort of have this percolating in their mind. Oh my God, I'm going to get in trouble, and I like working here, and I don't want to cause any waves. But it's your earning power on the line. And the sophisticated employers, most of them are, at least on this basic level, they're not going to fire you because you got legal advice. Now, there are occasions where we've seen and heard stories of having somebody being treated differently after that. They're not going to overtly state, hey, we're upset you got advice, but they might start getting treated differently. And so we tell them to keep a really careful journal with the date and things that are said or done. And in case this, devolves into an employment discrimination matter where they get fired or suspended. For example, before an injury, no write-ups, no disciplinary issues, nice clean record. And then after the injury, all of a sudden you see late for work or insubordination type of conduct or things like that. And you're looking at these two saying, wow, there's a real disparity here. They look like a nice valued worker beforehand. After the injury, they're getting written up left and right. So sometimes we'll refer that out to our colleague to see if there's a discrimination case there.
Well, what happens if it's a union? Can you still get involved if it's a union worker?
Yeah, we can. Some people just don't trust the the union attorneys that they're kind of assigned, and for whatever reason, good or bad, true or untrue, they want to get outside counsel. That happens a lot. I've represented a lot of union workers, and they have some extra protections under the law, which helps them in the workers' comp arena. So yeah, that happens on occasion where we get somebody who sort of wants to bypass the union attorney assigned to them. Maybe they think they're not going to fight quite as hard, or they're in alignment with the employer a little bit too much that makes them uncomfortable. So yeah, we can absolutely represent union workers.
Tell people the types of injuries that you normally work on.
Again, this would run the whole gamut. I mean, we have traumatic brain injuries, a lot of low back injuries. The low back gets hurt probably the most, just by the way we've evolved and the way our physical nature is, and we're not really meant to be bending and lifting heavy things. It puts a lot of load on the spine and force. So low back injuries, neck, of course, lots of shoulder injuries, especially from lifting heavy things or repetitive use. Remember, you can have a sudden traumatic injury in workers' comp. You fell off a ladder, you lifted a box, and you had back pain, or repetitive work trauma from day after day grind. But we have knees, hips, everything, burns, disfigurement, amputation cases, really everything. But I would say the low back is common. And believe it or not, a lot of lost finger cases. We get a lot of those, probably 4 or 5 every year, where somebody lost either, one or multiple fingers from an accident at work. So that's common too.
Do those get a very high settlement?
It really depends. There's a part of the Workers' Comp Act called specific loss. So if you lost a finger or amputated an arm or a limb, you can get a certain amount of weeks of workers' comp checks plus a healing period, even if it doesn't take you out of work. Normally, these things do take you out of work because they're serious injuries affecting your ability to do your job. So those cases, yeah, they can be high value. Same with the low back, because the low back can tend to be permanent for a lot of people. And there also can be a third-party case, especially with the amputation cases, where there may have been a defective machine. They didn't have the proper guard, and because they didn't have the proper guard, there's a third-party case, meaning a case not against the employer. Your remedy for that is your workers' comp, but against another entity, for example, the manufacturer of the machine, where you can get pain and suffering and other damages, unlike workers' comp. So we're always on the lookout for, do our workers' comp cases involve more than just comp? Maybe there's a third-party angle here. A lot of firms will miss that, and we make sure we don't.
We're talking settlements today. So everyone talks about workers' comp settlements. How do you get these settlements? How do you get these cases settled, Michael?
Well, first, if somebody's doing it on their own, and I know it sounds self-serving, but it's just the truth and nothing but the truth. You got to, whether it's our firm or someone else, get lawyered up. You're not going to do well on your own with settlement. It's just, unless you were out of work for 2 months and you're recovered and it's a small finite period, okay, you can try to negotiate that. But if it involves some permanent type of injury, you really need to get counsel involved. And we negotiate these by looking at a lot of factors: their age, the extent of the injury, what they did for a living, and how the injury affects their ability to earn money, whether they need surgery, what about medications, what about their residual earning power? Maybe they have a college degree and they could do sedentary work versus working with their hands. And so there's a lot of factors we look at to figure out, okay, what's the value of this case? It's always a certain range. It's never an exact science. And you submit a demand saying, here's what we would like. And then you wait for an offer and you go back and forth. And sometimes we do a mediation with a workers' comp judge to try to help us settle a case. But it takes a careful analysis. And that's, a lot of people try to get that golden nugget from us without signing up. They're like, how much is my case worth? I'm like, well, you're taking 25 years of experience, a long time in school, a lot of law school, some student debt, and you're going to ask for all that wisdom for nothing. It's like, well,
Yes.
the other part of that is we need their file to do it ethically, to make sure we know what the medical records say, and we have the whole puzzle together. And so, yeah, settlement is, I mean, really everybody asks about that because people don't want to be in the system. It's very demoralizing. You know, they're getting followed around sometimes. Their checks tend to be late.
That actually happens, Michael?
Pardon me, Steve?
That actually happens? They get followed around?
Oh, yeah, there's surveillance. Now there's been a shift from following people around in public, you know, sitting outside their street in a dark tinted window vehicle or following them around to wherever they're going shopping. There's still some of that, but now there's more of a social media investigation. And what are people posting? And do they have a side business? And is it on YouTube? And so they're really getting aggressive with trying to find out how active people are. So yeah, we always remind people, don't be posting when your case is active. You might put something and it gives the wrong idea. Then you have to explain it and it kind of puts you on defense. So yeah, surveillance is definitely part of the equation here.
Can you, you don't have to disclose the company, but can you talk about some of the settlement amounts you get?
Yeah, they really range. Really, I mean, there's no, every case is different. You know, you hear about that, like the idea in real estate, every piece of land is unique. Every workers' comp case is unique. And someone might settle for $5,000 because they sprained their back, but they're recovered. They were only out of work for, you know, a few months, and it's a small settlement, and they're on their way. In other cases, it could be $200,000, $50,000. We've settled a couple for 7 figures. But that's pretty rare in comp because we don't have a pain and suffering award. But, you know, depending on the person's average weekly wage and the extent of disability, the numbers can go pretty high. I would say 95% of the cases are settled under $250,000 for various reasons. The workers' comp has a lot of tools to challenge people's benefits. And you always have doctors with different opinions. And so the awards, the settlements tend to be lower than people would like because they're not personal injury cases, but they really run a big range. I mean, you're talking from, you know, it could be $500, but, you know, there's a lot of them in the $20,000, $30,000, $40,000 range. I would say that's probably 40 or 50% of them in that range.
You know, I wonder about some of these settlements. We get so many questions still about what if you contract COVID from an employee at work? Can you file on that?
Yeah, you can. Absolutely. That's a work-related illness. You can file for benefits. You file what's called a claim petition, and it's going to get assigned to a workers' comp judge like every other case. And you're going to have to litigate it and prove your case. Normally, you would do that by putting your client's testimony on, and also taking the deposition of a doctor, maybe an internal medicine doctor, or could be a family doctor, could be a specialist with, trying to think of the specialty off the top of my head. But you would need medical evidence to show within reasonable medical certainty that the doctor believes that so-and-so contracted COVID at work. And so it's absolutely a viable case. The strength of the case, case by case, of course, and they're very difficult because, as we know, COVID is not something you can touch or feel. And so a good defense lawyer is really going to vigorously cross-examine the injured worker about where they were in those days leading up to it, and who they were exposed to, and what stores they were at, and did they have a mask on, and what type of mask. And I mean, you could just go on and on and on if you wanted to be a pain defense lawyer and really, you know, drill down on that. So we actually didn't see as many as we thought during COVID. We had 2 or 3 cases, but a lot of them were short-term illness where somebody was sick for a few months and maybe they got short-term disability or unemployment comp, something like that in the interim, which didn't really make the workers' comp case very valuable to pursue. So a lot of them were smaller cases.
Michael, if somebody dies from an injury, does that go into a different area of law?
No, we have what's called death claims. And so you're entitled to the estate is entitled to, a certain amount for funeral costs. And then if there was a widow or widower, they could receive benefits up until they remarry, for example. If there's kids involved, there's a whole chart, and you have to really look at it carefully. Really, the issue is dependence. Was somebody dependent financially on the injured worker who perished? And then you look at the chart and figure out who's entitled to what. So yeah, we've had a couple of those along the way, sadly.
Okay, it worked very good, did they? You used to tell me, Michael, I guess maybe 8 or 9 months ago, when we started having viewers would ask about COVID, and you would tell me how hard it is to prove. So we've come a long way.
Yeah. Yep. It's absolutely right. Yeah. There's a little surge right now, unfortunately. Not to preach, but people need to be careful because, it's not completely gone. It's still with us in different degrees. So, we're still probably going to have some more work-related cases, down the road here.
Somebody had asked a couple of weeks ago, what happens if you're going to work and somebody attacks you, jumps you, and harms you? Is that work-related?
Unfortunately, no, if you're just commuting. For example, if you're just going to let's say you have a traditional job, 9 to 5, you leave your home and you go to a set place every day, an office building, and you're commuting. If you're hurt on that commute, it's not a work injury. Now, if you're at work already and you're going for a lunch break and you're on the property, that might be different. That might be a work injury. So commuting is not part of the scheme here for work-related injuries, but keep in mind there's a thing called a special assignment. For example, if your supervisor or the owner of your business said, "Hey, we need you to go drive down to the hardware store. We need new light bulbs for the kitchen." That's a specific mission. You're not commuting at that point. You're driving for a work-related purpose because your boss asked you to, and you get rear-ended or T-boned or assaulted in the store. That could be a work-related injury because you're in the course and scope of your employment. But if you're on your way to work, usually that's just commuting, and so that would not be covered.
Here's an area that people aren't going to want to hear about. What if you're an independent contractor?
Yeah, this comes up a lot, Steve. Independent contractors are not covered by the Workers' Comp Act. You have to be an employee. But not everybody who is called an independent contractor really is one. A lot of times, an employer, shouldn't use that word, but the entity will have you sign a document saying you're an independent contractor. But that's not the end of the equation for the workers' comp judges and the court system. They're going to look at control. And the more control they have over you, and maybe you're using their car and their tools, and they tell you where to go and where to be at a certain time, the more control there is, the more likely you're going to be deemed an employee. The lack of control, you have more control over things, the more likely you're going to be deemed an independent contractor. So we have cases that are really complicated where it's a really tough call. It seems like there's factors in one column, factors in the other column, and then the judge has to decide the issue. And then if you prove you're an employee, you go to the next phase of the case, which is disability. Did they get hurt? What's the extent of the injury, et cetera. So usually we try to bifurcate them, meaning let's just deal with this one issue alone. Were they an employee or not? Because if the answer is no, that's it. It's over.
Michael, our shows go by so fast. The good news is you have another show the last Tuesday of this month at 10 o'clock. Tell people how they can contact your office and your website.
Sure. 215-206-9068. That's our phone number. 215-206-9068. On the web at cardamonelaw.com. That's CARDAMONELAW. You can also get there by MyPhilly with a Y, workerscomp.com. That's MyPhillyWorkersComp.com. And we have a blog that a lot of people read. It's at paworkinjury.info. And so, yeah, you can reach us 7 days a week. We get back to people quickly, and we're happy to help if anybody needs it.
One of the finest workers' comp law firm in the state of Pennsylvania. Michael, we'll see you in about 3 weeks.
Sounds great.
Thank you so much. And as always, all of our shows are sponsored by the Michael Cardamone Law Firm. We'll be back with you next week with more Ask the Experts. Thanks, Michael.
Thank you. Bye-bye.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.